Welcome to U.S. Immigration TV. Well, the Child Status Protection Act, or CSPA, provides age-out protection for certain children beyond their 21st birthday, allowing them to be processed for a visa as though they were still under 21 years of age. Now, I know the law can be very confusing and complex. In this two-part video, I will explain first how to calculate a child's age and second, how to seek to acquire a visa. So make sure to watch this video and the second video, and of course to like, share, and subscribe to this channel. Well, first of all, for minor children of U.S. citizens, the CSPA is relatively simple and straightforward. File the petition before the child's 21st birthday. However, for other family-based petitions and employment-based petitions, the CSPA is a two-step process. First, calculate the child's CSPA age, and second, make sure the child seeks to acquire a visa within 1 year of when the priority date becomes current. Now, in this video, I will discuss how to calculate the child's age. In a future video, I will discuss how to satisfy the sought to acquire requirement. Well, the mathematical computation for determining a child's CSPA age, as I said, is complex and confusing. Number one, determine the processing time of the petition. You first have to determine how long it took the U.S. Citizenship and Immigration Services, or USCIS, to process and ultimately approve the underlying petition. And that is from the date the petition was filed to the date it was approved. Now, many people get confused on this processing time. And while, of course, documents from the National Visa Center will always list the priority date or the date the petition was filed, it is only the approval notice from USCIS that has the date of approval. It's the form I-797. So the question is, how long did it take the USCIS to process and approve the petition? Did it take them 1 month? Did it take them 1 year? Did it take them 3 years? And to be clear, the processing time of the petition is critical to CSPA eligibility. This is because you are able to subtract the processing time of the petition from the child's age when the priority date eventually becomes current. Now, ironically, the longer it takes USCIS to process and approve the petition, the better it is for the child because they can subtract more time from their age. And the faster the USCIS approves the petition, the less time the child's able to subtract from his or her age. Now, a lot of people get confused about the processing time. Some of them think that it's from the time the petition is filed until the priority date becomes current. No, that's not the case. I mean, for example, F4 petitions can take up to 25 years. It does not mean the processing time is 25 years to subtract from the child's age. It's just, when was the petition filed? When was it approved? And so even though it may take 20, 25 years for the priority date to become current, if that petition had been approved in 2 weeks, let's say it was filed on the 1st and by the 14th of that same month it's approved, you can only subtract 14 days. And many, many years ago, USCIS was very quick in approving petitions. They could do it in 1 month or even 2 weeks. Now they may be taking 2, 3, or 5 years, which, like I said, ironically would be better for a child in terms of the CSPA. Number two, determine visa availability. Now, visa availability is when the priority date becomes current on the monthly visa bulletin, which is published by the State Department. In fact, they have a website posting the priority dates. If the priority date on your petition is earlier than the date listed on the visa bulletin, then the priority date would be considered current. Now, if the child is processing their immigrant visa at the U.S. Embassy or outside the U.S., they would then use the final action dates chart on the visa bulletin to determine if their priority date is current. Now, if the child is adjusting status in the U.S., the USCIS allows the child to use the dates for filing chart in certain months, which is more beneficial to the child because the priority date becomes current earlier. Number 3, calculate the child's CSPA age. And this is when the priority date is current, you determine how old the child is or their biological age when the priority date becomes current. Then you subtract the processing time of the petition from their age and, of course, hope their age comes out to be under 21. For example, if the child is 23 years old when the priority date becomes current and it took USCIS 4 years to process and approve the petition, then subtracting those 4 years from the child's age would result in the child being under 21 years of age. On the other hand, if it took USCIS only 1 year to approve the underlying petition and the child is 23 years old, then they would be out of luck as their age would still be over 21 when the visa became available or priority date is current. Finally, number 4, seek to acquire a visa within 1 year. Now, assuming the child's CSPA age is calculated to be under 21, then they have 1 year to pursue their visa. And this is called sought to acquire. And I'm going to be discussing that in a separate video. Now, the CSPA is very complex and confusing. And if you have a child who is aged out or will be aging out and you believe the CSPA could benefit your child, I would strongly recommend that you consult with an attorney who can evaluate your situation, perform the necessary and complex mathematical computations to determine and prove your child's eligibility. Now, make sure to watch my next video about sought to acquire. And I hope you have found this video to be informative and helpful to you and your case. And of course, I will continue posting videos on this website or YouTube channel which I hope will be of interest to you. So make sure, of course, to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.